Solicitor General of India. What is the context? So the context is, recently the Appointments Committee of the Union Cabinet approved the reappointment of Tushar Mehta as the Solicitor General of India for 3 years. Now the first thing that we need to understand with regard to this article is what is this word cabinet implies. When it comes to the Union Cabinet, it basically consists of your Prime Minister plus the ministers of cabinet rank. Whereas when we talk about Council of Minister, it is a larger body. So it consists of your cabinet ministers, it consists of ministers of state, then it has deputy ministers, parliamentary secretaries, etc. So this Council of Ministers is a larger body, whereas cabinet is a smaller part. It is this cabinet which takes the decision, and the responsibility to enforce those decisions is up to the Council of Ministers. Now the next thing that we need to understand with regard to this article is what are cabinet committees. So these cabinet committees are responsible for reducing the workload of the cabinet, and they ensure better coordination among different ministries. When it comes to the cabinet committees, they are set up by the Prime Minister from time to time. So when we look at its composition, it varies from 3 to 8 members. It typically consists of cabinet ministers only, but non-cabinet ministers can also be a part of these cabinet committees. Okay, they can also be appointed as members of these cabinet committees. Then when it comes to the cabinet committees, they are extra constitutional in nature. That is, they are not mentioned in the constitution, rather they are established through Parliament's rules of business. As I told you, it is the Prime Minister who set up the cabinet committees from time to time. Now there are two kinds of cabinet committees. One is the standing committee, the other one is the ad hoc committee. So standing committees are one which are permanent in orientation. When it comes to ad hoc committee, they are set up to look into a specific matter. Okay, and once they have given their report with regard to that particular matter, they are done away with. Then when it comes to the cabinet committee, they are usually presided by the Prime Minister, if the Prime Minister is a part of that particular cabinet committee. But there are two cabinet committees, that is Cabinet Committee on Accommodation and Cabinet Committee on Parliamentary Affairs, which are not headed by the Prime Minister. Rest all are headed by the Prime Minister. So when it comes to Cabinet Committee on Accommodation, it is headed by your Home Minister, and when it comes to the Cabinet Committee on Parliamentary Affairs, it is headed by your Defence Minister. Okay. Whereas when we talk about Appointments Committee, which has approved the reappointment of Tushar Mehta as the Solicitor General of India, this committee is basically responsible for finalizing appointments to various top positions under the Government of India, and is currently composed of Prime Minister, Minister of Home Affairs and Minister of Corporation. Then the next thing that we need to look into is Solicitor General of India. Now when we talk about Solicitor General of India, he or she is basically there to assist the Attorney General of India. Now what is this Attorney General of India? Attorney General of India finds mention under Article 76 of the Indian Constitution. So this Attorney General of India is basically the highest law officer. When it comes to Solicitor General of India, he or she is the second highest law officer, because Solicitor General of India is there to assist the Attorney General of India when it comes to fulfilling his duties. Okay. When it comes to Attorney General of India, he is the highest law officer in the country. He is the chief legal advisor to the Union government. And he also represents the Union government in the cases which are there in Supreme Court and High Courts. Okay, so these are primarily the functions of Attorney General of India. The Attorney General of India has also been provided with certain rights. What are those? The parliamentary privileges also extend to Attorney General of India. He gets the right of audience in all the courts which are there in the territory of India. And lastly, he also gets the right to participate in the proceeding of both the houses of the parliament or any of its committees. When we talk about appointment of Attorney General of India, so he is appointed by the President. And only such a person can be appointed as Attorney General of India who is qualified to be appointed as a Supreme Court judge. That means this person needs to be a citizen of India. This person could either be a High Court judge for 5 years, or he should be an High Court advocate or High Court in succession for 10 years. If he has these qualifications or he is a distinguished jurist in the eyes of the President, then that person can be appointed as Attorney General of India. When we talk about the removal of Attorney General of India, the Constitution has not specified any particular procedure when it comes to the removal of Attorney General of India. He holds the office till the time he enjoys the pleasure of the President. Normally, what happens when the cabinet resigns, or when basically the Council of Ministers resigns, then the Attorney General of India also resigns from his office. Now, again coming back to Solicitor General of India. Now, as we discussed that the Attorney General of India finds mention under Article 76 of the Indian Constitution. But when you talk about Solicitor General of India or when you talk about additional Solicitor Generals, they do not find mention in the Indian Constitution. They are merely to assist the Attorney General of India when it comes to fulfilling his duties. Okay. Now, when it comes to the rules which regulates remuneration, duties and other terms and conditions of Solicitor General of India, along with Attorney General and additional Solicitor General, they are defined under Law Officers Conditions of Service Rule 1987. When it comes to the terms of office for Solicitor General of India, so Solicitor General remains in office for a period of 3 years and is eligible for reappointment. What has happened right now? For a further term not exceeding 3 years. His appointment can be terminated by 3 months' notice in writing by either side at any time during his tenure. Now, what are the duties which the Solicitor General of India has to perform? So, he is supposed to advise the government on legal matters, the way Attorney General of India also does. Okay? And to perform duties of legal character which are referred to or assigned to him by the government. Then, to present the government in Supreme Court or in any High Court in cases which relates to suits, writ petition, appeal and other proceedings where the government is concerned or is a party or otherwise interested in. When it comes to the writ petition, the Supreme Court can issue writs for enforcement of fundamental rights only. But when it comes to the High Court can issue writs for enforcement of fundamental right as well as legal rights. Okay. Then another duty is to represent the government in any reference made by the President to the Supreme Court under Article 143 of the Indian Constitution. Now, what is Article 143 of the Indian Constitution? So, under this, the President can consult the Supreme Court and can seek the opinion of Supreme Court on questions of law or fact which are of public importance and that has arisen or is likely to arise regarding matters of public importance. Another aspect on which the President can seek the opinion of the Supreme Court under Article 143 is if a dispute relates to pre-constitutional treaty or agreement. Now, just keep this thing in mind. When it comes to the first aspect, that is if a matter is related to, important question of law, or that question is of great public importance. In this regard, the Supreme Court may give its opinion or it may refuse to give its opinion. But when it comes to the matters which relates to disputes which pertains to pre-constitutional treaties or agreement, in this the Supreme Court must give its opinion. But in both the cases, the opinion of the Supreme Court is not binding on the President. Okay, that is why they are referred as advisory jurisdiction of the Supreme Court. It is not binding on the President. And another aspect that you need to make note of from your prelims perspective is all the matters which are referred to the Supreme Court under Article 143 by the President, they need to be looked into by a bench which should have at least 5 Supreme Court judges. Okay? Not less than 5. Then lastly, the Solicitor General of India has to discharge other functions which are conferred by or are under the constitution or any other law for the time being in force. What are the restrictions which are there with regard to this office? So he cannot hold briefs in any court for any party except the Government of India or the government of a state or any university or any other government entity. Cannot advise any party against the Government of India or a public sector undertaking. This is to avoid conflict of interest. Okay. He cannot defend an accused person in a criminal prosecution without permission of Government of India. Why? Because when we talk about civil cases, this is a matter or this is a dispute between two individuals. But when you talk about criminal cases, so in this, one of the party is your state. Because these are offences against the state. That is why when it comes to the criminal matters, the Solicitor General of India cannot defend an accused person without the permission of Government of India. Then he cannot accept appointment to any office in any company or corporation without the permission of Government of India, again to avoid conflict of interest. And he cannot advise any ministry or department of Government of India or any statutory organization or any public sector undertaking without any orders from Ministry of Law and Justice.